so we talked about some different methods to terminate contracts. Right now, we want to talk about methods and ways to terminate an offer. Now, remember, don't confuse these two. You know, an offer is something you do prior to the contract. Now, once all parties have agreed to the offer, then it becomes a contract. So how you terminate an offer is not necessarily the same way you terminate a contract. So just beware. But obviously the first way to terminate an offer is just simply by rejection. You know, if I submit an offer to the seller, the offeree, and by the way, you're going to start seeing, in fact, we've already seen quite a bit, and I probably should have already told you this, but you see, you're going to see a lot of terms ending in OR and EE, and maybe I've already told you this, but in case I haven't, you got to make sure you know who's who, because like in the book, I try to put like in parentheses who the offeror is, who the offeree is, and so forth. But on the state exam, they're probably not going to have anything in parentheses. So if you thought the offeror was the seller, and they'll probably have an answer to match whatever you thought they were, then a good chance you're going to get that wrong. So make sure, pay attention to all these terms dealing with OR and EE. I think a very common way most people try to remember or think about this, if you can remember, the OR is the one always giving something. The EE is receiving. So the offeror is giving the offer. That's obviously the buyer. The offeree is receiving the offer. So that's typically the seller. Okay. So just beware of these ORs and EEs, because that can trip you up if you're not careful. But anyway, once the seller receives an offer, they may just say, this is such a ridiculous offer, it's not even close enough to counter or even negotiate anything at all. So they might just reject it outright. Obviously, that would terminate the offer at that point. Okay? A counter offer. We've talked about this already. But if either party makes a counter offer, counters the other party's offer, that terminates the original offer. So there's no going backwards here. I'm just telling you, you need to let your clients know. If we need to make a counter offer, make it. I'm in no way suggesting you should not be making counter offers. But I want my client to understand what's happening here when they make that counter offer. Because when you make that counter, everything prior to that point is now terminated. It's void. It never even existed. So make sure your client's not just making a counter, and in their mind they might be thinking, well, if the other party doesn't accept my counter, then I'll just go with their original offer. Well, you can't do that because you've now voided the original offer. So, just make sure they understand what they're doing when they make the counter offer. Okay? Typically I ask them, we'll make the counter offer, but if they say no, seller, if they reject it and decide to walk away, which is within their right, are you okay with that? If you're okay with that, let's make the counter. But if you're not going to be okay with losing this buyer, then you better think long and hard before you decide to make this counter offer. Again, so you just want to make sure they understand what they're doing when they do it. All right. Expiration. Obviously, if your offer expires, that would terminate the offer. And if you're not familiar with this, typically, anytime the buyer in particular makes an offer, They'll write in the offer that our offer is good. They might be good for 24 hours or 48 hours or a week. It's a fill in the blank, so there's no right or wrong answer there. But in essence, you're just trying to let the seller know, I'm not hanging around here forever. Here's my offer. Either accept it or counter it, do something. But after say you put in there 48 hours, then this offer will expire in 48 hours. So if the seller comes back later after the expiration date and decides to accept the offer, then the buyer is not bound to it because their offer had expired. It's no longer good. But I'll also, just so you know, that expiration is quite important. Okay. I've actually seen where some agents have written up offers for their buyer and they didn't even put an expiration date. That can cause some significant legal problems down the road, potentially. Because if your offer never expires, say you make the offer, no expiration date, days go by, maybe a week or so goes by, and you never even hear anything from the seller. It happens, trust me. And what's really sad there, a lot of times you never even hear from their agent. Their agent won't even respond to you, for crying out loud. So it's been days, maybe even a week or so, and obviously the assumption is they've just thrown my offer in the trash. They were not happy with that at all. So we just go looking for something else. We find another property, we like it, we make an offer, they accept it. You buy the house, and then say a couple months down the road, 2 or 3 months maybe down the road, that first homeowner decides to come back and say, all right, well, we've thought about your offer that you submitted 3 months ago, and we've decided to accept it. Guess what? You're under contract to buy that house because your offer was never terminated, right? So, you want to put an expiration date in there. Excuse me. And, we get into the Unit 2 course. We'll talk a little more specifically about how to do this and things to consider when it comes to, how long should you give the seller before they have to respond to your offer. I'll tell you, common, 24, 48 hours, something like that. But sometimes there are other things you need to consider. But again, it's a fill in the blank type situation. So there's no right or wrong. But I do suggest you at least put an expiration date. And I wouldn't go put some other property under contract until after your original offer, first offer, has expired. Okay? All right. Revocation. If you recall, can the buyer revoke or rescind their offer without penalty? They've already made their offer. Could they decide to rescind the offer? Pull it back, say, I'm kidding, I don't want the house, or whatever. Obviously, they can do that as long as they have not been notified of acceptance. So as long as they haven't been notified of acceptance, they can rescind or revoke the offer at any time up to that point. Now, I do want to be clear on this as well. Let's say the seller's agent, the listing agent, contacts the buyer's agent and says, we've accepted your offer. The seller's accepted it. It'll probably be a couple of hours. I need to get back to the office, and then I'll send you a copy of the contract, of the accepted contract. But just wanted to let you know we have accepted your offer. Well, that's notification, right? Been notified. But within that couple of hours, while we're waiting on the hard copy, let's say the buyer contacts their agent and says, you know what, we've been talking, me and the wife, me and the husband, we've been talking, and we've just decided this is not the right house for us, so we want to rescind our offer. We want to look at something else. Can they do that? Because now the buyer's agent never told the buyer about the notification of acceptance. They were just waiting to get the hard copy back, and then I guess we're going to talk to the buyer about it. Well, at this point, because the buyer did not know, the buyer was not notified of the acceptance. Their agent was, but the buyer wasn't. Can the buyer still now revoke the offer without penalty? No. Because once the buyer's agent's been notified, then the buyer is presumed notified. The reason I point this out, one, obviously you need to know that, but two, if you're that buyer's agent and you get notification of acceptance, you better promptly let your buyer know. Hey, look, I just got a call from the listing agent. Good news. They've accepted the offer. We should get a copy of the ratified contract within the next hour or two. But just wanted to let you know the seller has accepted the offer. If you don't do that and now they come back wanting to terminate, now they're going to be mad at you. What do you mean they accepted it? Why didn't you tell me? We didn't know that. So here you go. I'm telling you, you better keep people posted. Keep people abreast of what's going on here. You're going to have problems. Death obviously has a way of terminating a lot of things. But if you make an offer on a house, obviously that will also terminate your offer. Now, you remember I said at the beginning of this little piece of this section here, there's a difference between terminating contracts and terminating offers. And this is one of them. Obviously, if the buyer dies, if they make an offer and then die, very soon afterwards, then obviously that's going to terminate the offer. Whether the seller accepts it or not, after the point is irrelevant because, the buyer's dead. They're not going to buy the house, okay? So death will terminate the offer. However, if it were, if the contract had already been accepted, ratified, we're just now waiting to close, and say the seller dies, what's the status of the contract? It's not terminated, or at least not automatically terminated. Because in a situation like that, the buyer could say, well, we still want to buy the house, and because they agreed to the terms of the sale before the seller died, right? So they could certainly, now it might take a little bit longer. Might have to wait on probate or whatever, but that does not terminate the contract. You could still buy it. Now, if they wanted to terminate it, the buyer, that is, they could. But the point I'm trying to make here is, if you're still in just the offer stage, offer, counter offer stage, and either party dies, you're done. It's over. But once the contract's been ratified, now if the buyer dies, again, it's over. It's very difficult, from my understanding, to make a dead person purchase the property. It's going to be pretty difficult. But if the seller dies, the buyer kind of has an option here. They can go ahead and terminate the contract because the other person that could enforce the contract is now dead, so they can't do that. But if the buyer wants to buy still, then they obviously can. So I just want to kind of clarify that real quick. And then there's always methods to terminate an offer dealing with the operation of law. Obviously the law will always win. There could be any number of reasons that an offer could be terminated based on law. Just for example, bankruptcy is very common. A lot of people will file for bankruptcy. And I will tell you, if it's the buyer and you file for bankruptcy, your offer is terminated. You cannot get a loan to buy a house if you file for bankruptcy. And quite frankly, if the seller files for bankruptcy, then the seller cannot sell their house. We could get into the weeds right there, but we're not. So just understand, if either party files for bankruptcy, that's going to terminate the offer. You're done. Okay, that's considered operation of law. But now let's talk about this breach of contract. Now we're actually under contract, right? Contract's ratified. Well, what does breach of contract mean? That means that one of the parties have failed to perform or do something they agreed to. Typically, not all the time, but typically when there's a breach of contract, it's going to be by the buyer. And what's the breach? Again, typically, they don't buy the house. They don't close. For whatever reason, they never buy the property. Well, you're in breach of contract. When you enter that contract, that's a legal document. You're under contract to purchase according to the terms you agreed to in the contract. Now, if you don't buy it, if we never close, then you're in breach of contract. Okay? So what happens there? Because obviously that could create, in some cases, significant damages to the other party. Now look, I'm saying the buyer here, typically it is the buyer when there's a breach of contract. But I'm telling you, I've had to deal with transactions where the seller actually was in breach of contract, where they just decided at the last minute, I'm not selling. Now that's a lot more rare. Okay, you don't see it as often as you do with buyers, but either party could be in breach of contract. And when you're in breach, not only could you be liable for liquidated damage, which we're going to talk about some of this here in a second, but also actual damages. There could be a lot of financial loss here potentially that you've caused to the other party. So what are the remedies if there is a breach of contract? One, you could just file a suit for damages. Obviously, whichever party has actually suffered damages, they could notify the other party, okay, well, now that you're in breach, here are the damages that you've caused me. And if you would, make the check out to Frankie Griffin, please. Right? That works good if the buyer agrees to write the check to you. But what if they say, no, I'm not doing that. I'm not paying for that. That's ridiculous. I'm not paying. Then the next thing you may have to do is sue for what they call specific performance. Basically, specific performance meaning you're filing a lawsuit. You're suing the other party. And basically what you're asking the courts to do is, look, the buyer said they were going to buy my house, and they said they were going to do it under these terms that we've agreed to in the contract. And court, we want you to force the buyer to buy the property. That's specific performance. Well, obviously the courts can't force someone to buy something if they decide not to. However, if you choose not to, buyer, here are the damages you created by entering into the contract and then being in default, and you must pay this back to the other party. So the courts can order these damages to be paid to the harmed party, right? That's specific performance. A lot of times we can just settle with as liquidated damages, which is probably 90 or 95% of the time. This is how we resolve the breach of contract, is through this liquidated damages. Liquidated damages are awarded when there's maybe no actual financial loss other than just some time, aggravation, I'm kind of irritated because we went through all this with this buyer and now they're wanting to back out. Y'all, it's very frustrating to say the least. So y'all, this is what we might consider liquidated damages. Okay, maybe the seller didn't actually lose a bunch of money because of it, but due to the hardship that was created, we at least want liquidated damages. Well, how much will that be? Typically, that's going to be whatever the earnest money was. Again, we'll talk more about this when we actually get into the provisions of a contract of sale. But typically when the buyer makes an offer, they'll put up some amount of money to go with their offer. Y'all call it earnest money. There's no set amount that it has to be. In fact, you don't even have to put up any earnest money. But it is very typical, common, that a buyer will put up at least some amount of earnest money. Y'all say it was $1,000. And I will tell you that's another negotiable item within the contract. But say they put up $1,000. Well, that $1,000 is what's going to be used as liquidated damages if the buyer does not buy. So this is something the seller needs to be really thinking about pretty hard. When they're thinking about accepting the offer, well, what if the buyer defaults or is in breach of contract? They put up $1,000 earnest money. If they don't close, is that enough? Is that enough to make me happier or to cover my irritation or whatever? That the seller might say, well, no, we want $3,000 or $5,000 or whatever. Again, so the earnest money is certainly a negotiable item within the contract for sure. But for now, just know, the earnest money is what's put up along with the offer. Buyer, you need to understand if you are found to be in breach of contract, because you don't do what you agreed to do, chances are you're going to lose whatever earnest money you put up with the offer. Okay? So we need to understand that. But that earnest money, that's what's going to be used as liquidated damages.